We will, I suppose, have this debate again next week, if we ever get there. It's getting late. I would ask you respectfully if we could simply start. Maybe tomorrow we can start, and they can make their argument, and they can, I guess, make a case that they once called overwhelming. We'll see. But this resolution is right, and it's fair, and it makes sense. You have a right to hear what they have to say before you have to decide these critical issues. That's all this is about. Is it now, or is it a week from now? Seriously, can we please start? Thank you.
It's remarkable that after taking the action of the breathtaking gravity of voting to impeach the duly elected President of the United States, and after saying for weeks that they had overwhelming evidence to support their case, the first thing that the House managers have done upon arriving finally in this chamber after waiting for 33 days is to say, well, actually, we need more evidence. We're not ready to present our case. We need to have subpoenas and we need to do more discovery because we don't have the evidence we need to support our case. This is stunning. It's a stunning admission of the inadequate and broken process that the House Democrats ran in this impeachment inquiry that failed to compile a record to support their charges. It's stunning that they don't have the evidence they need to present their case and that they don't really have a case. If a litigant showed up in any court in this country on the day of trial and said to the judge, actually, Your Honor, we're not ready to go. We need more discovery. We need to do some more subpoenas. We need to do some more work. They'd be thrown out of court and the lawyers would probably be sanctioned. This is not the sort of proceeding that this body should condone. Consider what's really at issue in the resolution here and the amendment. It's a matter of timing. It's a matter of when this body will consider whether there should be witnesses or subpoenas for documents. Why is it that the managers, the House managers, are so afraid to have to present their case, remember, they've had weeks of a process that they entirely controlled. They had 17 witnesses who testified first in secret and then in public. They've compiled a record with thousands of pages of reports, and they're apparently afraid to just make a presentation based on the record that they compiled and then have you decide whether there's any there, whether there's anything worth trying to talk to more witnesses about. Why is it that they can't wait a few days to make their presentation on everything they've been preparing for weeks and then have that issue considered? Because they don't think that there is any there, and they want to ram this through now. And they want to ram this through now when it's something that they themselves failed to do. So I want to unpack a couple of the aspects of what they're asking this body to do. Part of it relates to the broken process in the House, how that process was inadequate and invalid and compiled an inadequate record. And part of it has to do with what accepting their request to have this body do their job for them would do to this institution going forward, and how it would alter forever the relationship between the House and the Senate in impeachment proceedings. So first, as to the process in the House, what they're asking, the House manager asking this body to do now is really to do their job for them, because they didn't take the measures to pursue these documents in the House proceedings. And there have been a number of statements made about they tried to get the documents and no executive privilege was asserted and things like that. Let's look at what actually happened. They issued a subpoena to the White House. And the White House explained, and we were told a few minutes ago that the White House provided no response, it provided no rationale. That's not true. In a letter of October 18th, White House Counsel Pat Cipollone explained in 3 pages of legal argument why that subpoena was invalid. And that subpoena was invalid because it was issued without authorization. We've heard a lot today about how the Constitution assigns the sole power of impeachment to the House. That's right. That's what Article 1, Section 2 says. It assigns the sole power of impeachment to the House, not to any member of the House. And no committee of the House can exercise that authority to issue subpoenas until it's been delegated that authority by a vote of the House. There was no vote from the House. Instead, Speaker Pelosi held a press conference And she purported, by holding a press conference on September 24th, to delegate the authority of the House to Manager Schiff and several other committees and have them issue subpoenas. All of those subpoenas were invalid. And that was explained to the House, to Manager Schiff and the other chairman of those committees at the time in that October 18th letter. Did the House take any steps to remedy that? Did they try to dispute that? Did they go to court? Did they do anything to resolve that problem? No. Because as we know, all that they wanted to do was issue a subpoena and move on. They just wanted to get through the impeachment process as quick as possible and get it done before Christmas. That was their goal. Those subpoenas were unauthorized. Now, what about some of the other things that they brought up? The witnesses. Witnesses who were directed not to testify. And part on this, we've heard Manager Schiff say several times that the White House never asserted executive privilege. Well, let me be clear on that. That's a lawyer's trick, because it is technically true that the White House didn't assert executive privilege, because there's a particular situation in which you do that in a particular way that you do that. But there's another doctrine of immunity of senior advisors to the president that is based on the same principles as executive privilege, and that has been asserted by presidents of both political parties since the 1970s at least. This is what one attorney general explained about that. Quote, "The immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests." End quote. That was Attorney General Janet Reno in the Clinton administration, explaining that senior advisors to the president are immune from congressional compulsion. And that doctrine, that immunity, is rooted in the same principles of executive privilege. It's been asserted by all presidents since the 1970s, and that was the basis on which a number of the advisors whose pictures they put up were directed not to testify. Did they try to challenge that in court? Did they go to court on that one? Did they try to go through the constitutionally mandated accommodations process to see if there was a way to come up with some aspect of testimony could be provided? No, none of that. They just wanted to forge ahead, rush through the process, not have the evidence, and then use that as another charge in their charging sheet for the impeachment, calling it obstruction of Congress. And what that is, as Professor Turley explained, this idea that when there's a conflict between the executive branch and the House and seeking information, and the president is asserting constitutionally based privileges, that's part of the operation of separation of powers. That is the president's constitutional duty to defend the prerogatives of the office for the future occupants of that office. And it is not something that can be charged as an impeachable offense, as the House Democrats have tried to say here. To do that is an abuse of power. That's what Professor Turley explained. It's the House Democrats' abuse of power. We just heard Manager Lofgren refer to executive privilege as a distraction. She was asserting that these issues of executive privilege are just a distraction that shouldn't hold things up. But this is what the Supreme Court has said about executive privilege in Nixon versus the United States, that the protections for confidentiality and executive privilege are, quote, fundamental to the operations of government and inextricably rooted in the separation of powers under the Constitution, end quote. Inextricably rooted in the separation of powers. That's why it's the president's duty to defend executive branch confidentiality interests, and that is what the president was doing here. Now, the process that they pursued in the House abandoned any effort beyond issuing the first subpoena that was invalid to work out an accommodation with the White House, and instead just tried to rush ahead to have the impeachment done by Christmas. What does that lead to now? They're coming to this body after a process that was half-baked, that didn't compile a record sufficient to support their charges, and asking this body to do their job for them. Now, as Leader McConnell pointed out in some comments earlier today, to allow that, to accept the idea that the House can bring an impeachment here that is not adequately supported, that has not been investigated, that has not got a record to support it, and to turn this body into the investigatory body would permanently alter the relationship between the House and the Senate in impeachment proceedings. It's not the role of the Senate to have to do the House's job for them. It's not the role of the Senate to be doing an investigation and to be doing discovery in a matter like the impeachment of a president of the United States. If the House has not done the investigation and cannot support its case, it's not the time once it arrives here to start doing all that work. That's something that's the House's role. This is something that is important for this institution, I believe, not to allow the House to turn it into a situation where this body would have to be doing the House's work for it. If there is not evidence to support the case, if they haven't done their investigation, then they're not going to be able to support their case. Again, what's at issue here, and I think it's important to recall on the issue of this amendment, it's not whether the Senate, whether this body will be considering whether there should be witnesses or not, but when that should be considered. And there is no reason not to take the approach that was done in the Clinton impeachment. 100 senators agreed then that it made sense to hear from both sides before making a determination on that, to hear from both sides to see what sort of case the House could present and the president's defense. And that makes sense. In every trial system, there is a mechanism for determining whether the parties have actually presented a triable issue, whether there is really some there that requires the further proceedings. And this body should take that common sense approach and hear what it is that the House managers have to say. Why are they afraid to present their case? They had weeks in a process that they controlled to compile their record, and they should be able to make that presentation. The one point that I will close on, we've heard Manager Schiff say several times that we have to have a fair process here, and I was struck by it that at one point he said if you allow only one side to present evidence, the outcome will be predetermined. The outcome will be predetermined. That's exactly what happened in the House. Let's recall that the process they had in the House was one-sided. They locked the president and his lawyers out. There was no due process for the president. They started with secret hearings in the basement. The president couldn't be present by his counsel. He couldn't present evidence. He couldn't cross-examine witnesses. And then there was a second round in public where again they locked the president out. And we've heard, they just said that the president had an opportunity to participate. In the third round of hearings that they held before the Judiciary Committee, after one hearing on December 4th, Speaker Pelosi, on the morning of December 5th, went out and announced the conclusion of the Judiciary Committee proceedings. She announced that she was directing Chairman Nadler to draft articles of impeachment. That was before the day that they had set for the president even to tell them what rights he wanted to have and to exercise in their proceedings. It was all already predetermined. The outcome had been predetermined. The Judiciary Committee had already decided it was not going to have any fact hearings. There was no process for the president. He was never allowed to participate. So when Chairman Schiff says here that if you only allow one side to present evidence, that predetermines the outcome, that's what they did in the House, because they had a predetermined outcome there, because it was all one-sided. And for him to lecture this body now on what a fair process would be takes some gall. A fair process would be when you come to the day of trial, be ready to start the trial and present your case, not ask for more discovery. The president is ready to proceed, and the House managers should be ready to proceed, and this amendment should be rejected.
Senator Schumer said earlier today that the eyes of the founders are on these proceedings. Indeed, that's true. But it is the heart of the Constitution that governs these proceedings. And what we just heard from Manager Schiff, courts have no role, privileges don't apply. What happened in the past, we should just ignore. In fact, Manager Schiff just said, try to summarize my colleague's defense of the president. He said, not in those words, of course, which is not the first time, Mr. Schiff, has put words into transcripts that did not exist. Mr. Schiff also talked about a trifecta. I'll give you a trifecta. During the proceedings that took place before the Judiciary Committee, the president was denied the right to cross-examine witnesses. The president was denied the right to access evidence. And the president was denied the right to have counsel present at hearings. That's a trifecta that violates the Constitution of the United States. Mr. Schiff did say the courts really don't have a role in this. Executive privilege, why would that matter? It matters because it's based in the Constitution of the United States. One manager said that it is you that are on trial, the Senate. He also said that, and others did, that you're not capable of abiding by your oath. And then we had the invocation of the ghost of the Mueller report. I know something about that report. It came up empty on the issue of collusion with Russia. There was no obstruction. In fact, the Mueller report, to the contrary of what these managers say today, came to the exact opposite conclusions of what they say. Let me quote from the House impeachment report at page 16. Although President Trump has in times invoked the notion of due process, an impeachment trial, an impeachment inquiry is not a criminal trial and should not be confused with it. Believe me, what has taken place in these proceedings is not to be confused with due process, because due process demands, and the Constitution requires, that fundamental fairness and due process, we're hearing a lot about due process is designed to protect the person accused. When the Russia investigation failed, it devolved into the Ukraine, a quid pro quo. When that didn't prove out, it was then bribery or maybe extortion, or somebody said, one of the members or the members of the House said treason. But instead we get two articles of impeachment. Two articles of impeachment that have a vague allegation about a non-crime allegation of abuse of power and obstruction of Congress. Managers, right here, before you today, who have said that executive privilege and constitutional privileges have no place in these proceedings. On June 28, 2012, Attorney General Eric Holder became the first United States Attorney General to be held in both civil and criminal contempt. Why? Because President Obama asserted executive privilege. With respect to the Holder contempt proceedings, Mr. Manager Schiff wrote, the White House assertion of privilege is backed by decades of precedent that has recognized the need for the president and his senior advisors to receive candid advice and information from their top aides. Indeed, that's correct. Not because Manager Schiff said it, but because the Constitution requires it. Mr. Manager Nadler said that the effort to hold Eric Holder, Attorney General Holder, in contempt for refusing to comply with various subpoenas was, quote, politically motivated, and Speaker Pelosi called the Holder matter, and I quote, a little more than a witch hunt. What are we dealing with here? Why are we here? Are we here because of a phone call? Or are we here before this great body because since the president was sworn into office, there was a desire to see him removed? I remember in the Mueller report, there were discussions about, insurance policies. The insurance policy didn't work out so well. So then we moved to other investigations. I guess you would call it reinsurance or an umbrella policy. And that didn't work out so well. And here we are today. Manager Schiff quoted the Supreme Court, and I'd like to make reference to the Supreme Court as well. It was then Justice Rehnquist, later to be Chief Justice Rehnquist, who wrote for the majority in United States versus Russell in 1973. These are the words. We may someday be presented with a situation in which the conduct of law enforcement agents is so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. That day is today. That day was a year ago. That day was in July when Special Counsel Mueller testified. I am not today going to take the time to review, and I will do it later, the pattern and practices of irregularities that have gone on in these investigations from the outset. But to say that the courts have no role, the rush to impeachment, to not wait for a decision from a court on an issue as important as executive privilege, as if executive privilege hasn't been utilized by presidents since our founding. This is not some new concept. We don't waive executive privilege, and there's a reason we keep executive privilege, and we assert it when necessary. And that is to protect the Constitution and the separation of powers. The president's opponents, in their rush to impeach, have refused to wait for complete judicial review. That was their choice. Speaker Pelosi clearly expressed her impatience and contempt for judicial proceedings when she said, "We cannot be at the mercy of the courts." Think about that for a moment. We cannot be at the mercy of the courts. So take Article 3 of the United States Constitution, remove it. We're acting as if the courts are an improper venue to determine constitutional issues of this magnitude. That is why we have courts. That is why we have a federal judiciary. It was interesting when Professor Turley testified before the House Judiciary Committee in front of Mr. Nadler's committee. He said, "We have 3 branches of government, not 2. If you impeach a president, if you make a high crime and misdemeanor out of going to courts and abuse of power, it's your abuse of power." You know, it's more than that, a lot more than that. There's a lot more than an abuse of power if you say the courts don't apply. Constitutional principles don't apply. Let's start with a clean slate as if nothing happened. A lot has happened. As we proceed in the days ahead, we will lay out our case. We're going to put forward to the American people, but more important, for the Constitution's sake, what's taken place here. But this idea that we should ignore what has taken place over the last 3 years is outrageous. We believe that what Senator McConnell has put forward provides due process, allows the proceedings to move forward in an orderly fashion. 33 days. 33 days they held on to those impeachment articles. 33 days. It was such a rush of national security to impeach this president before Christmas that they then held him for 33 days. To do what? To act as if they negotiate, the House of Representatives should negotiate the rules of the United States Senate. They didn't hide this. This was the express purpose. This was the reason they did it. We're prepared to proceed. Majority Leader, Democratic Majority Leader, we're prepared to proceed. In our view, these proceedings should begin.
It's very difficult to sit there and listen to Mr. Schiff tell the tale that he just told. Let's remember how we all got here. They made false allegations about a telephone call. The President of the United States declassified that telephone call and released it to the public. How's that for transparency? When Mr. Schiff found out that there was nothing to his allegations, he focused on the second telephone call. He made false, and his colleagues made false allegations about that second telephone call that occurred before the one he had demanded. So the President of the United States declassified and released that telephone call. Still nothing. Again, complete transparency in a way that, frankly, I'm unfamiliar with any precedent of any President of the United States releasing a classified telephone call with a foreign leader. When Mr. Schiff saw that his allegations were false, and he knew it anyway, what did he do? He went to the House and he manufactured a fraudulent version of that call. He manufactured a false version of that call. He read it to the American people, and he didn't tell them it was a complete fake. Do you want to know about due process? I'll tell you about due process. Never before in the history of our country has a president been confronted with this kind of impeachment proceeding in the House. It wasn't conducted by the Judiciary Committee. Now, Mr. Nadler, when he applied for that job, told his colleagues when they took over the House that he was really good at impeachment. But what happened was the proceedings took place in a basement of the House of Representatives. The president was forbidden from attending. The president was not allowed to have a lawyer present. In every other impeachment proceeding, the president has been given a minimal due process. Nothing here. Not even Mr. Schiff's Republican colleagues were allowed into the SCIF. Information was selectively leaked out. Witnesses were threatened. Good public servants were told that they would be held in contempt. They were told that they were obstructing. What does Mr. Schiff mean by obstructing? He means that unless you do exactly what he says, regardless of your constitutional rights, then you're obstructing. The president was not allowed to call witnesses. By the way, there's still evidence in the SCIF that we haven't been allowed to see. I wonder why. No witnesses. Now let's think about something else for a second. Let's think about something else. They held these articles for 33 days. We hear all this talk, an overwhelming case that they're not even prepared today to stand up and make an opening argument about. That's because they have no case. Frankly, they have no charge. When you look at these articles of impeachment, they're not only ridiculous, they are dangerous to our republic. And why? First of all, the notion that invoking your constitutional rights to protect the executive branch, that's been done by just about every president since George Washington, that is obstruction. That is our patriotic duty, Mr. Schiff, particularly when confronted with a wholesale trampling of constitutional rights that I'm unfamiliar with in this country. Frankly, it's the kind of thing that our State Department would criticize if we see it in foreign countries. We've never seen anything like it. And Mr. Schiff said, have I got a deal for you? Abandon all your constitutional rights, forget about your lawyers, and come in and do exactly what I say. No, thank you. No, thank you. And then he says he has the temerity to come into the Senate and say, we have no use for courts. It's outrageous. Now, let me tell you another story. There's a man named Charlie Kupperman. He is the Deputy National Security Advisor. He is the number 2 to John Bolton. Because you have to remember, Mr. Schiff wants you to forget, but you have to remember how we got here. They threatened him. They sent him a subpoena. Mr. Kupperman did what any American should be allowed to do, used to be allowed to do. He was forced to get a lawyer. He was forced to pay for that lawyer. And he went to court. Mr. Schiff doesn't like courts. He went to court and he said, Judge, tell me what to do. I have obligations that frankly rise to what the Supreme Court has called the apex of executive privilege in the area of national security. And then I have a subpoena from Mr. Schiff. What do I do? You know what Mr. Schiff did? Mr. Kupperman went to the judge and the House said, never mind, we withdraw the subpoena. We promise not to issue it again. And then they come here and they ask you to do the work that they refuse to do for themselves. They ask you to trample on executive privilege. Now, would they ever suggest that the executive could determine on its own what the speech or debate clause means? Of course not. Would they ever suggest that the House could invade the discussions that the Supreme Court has behind closed doors? I hope not. But they come here and they ask you to do what they refuse to do for themselves. They had a court date and they withdrew the subpoena, they evaded a decision, and they're asking you to become complicit in that evasion of the courts. It's ridiculous, and we should call it out for what it is. Obstruction for going to court? It's an act of patriotism to defend the constitutional rights of the president, because if they can do it to the president, they could do it to any of you, and they could do it to any American citizen, and that's wrong. And Lawrence Tribe, who's been advising them, I guess he didn't tell you that in the Clinton impeachment, he said, it's dangerous to suggest that invoking constitutional rights is impeachable. It's dangerous. And you know what? It is dangerous, Mr. Schiff. So what are we doing here? We have the House that completely concocted a process that we've never seen before. They locked the president out. Oh, and by the way, will Mr. Schiff give documents? We asked him for documents. We asked him for documents when, contrary to his prior statements, it turned out that his staff was working with the whistleblower. We said, let us see the documents, release them to the public. We're still waiting. So the idea that they would come here and lecture the Senate. By the way, I was surprised to hear that, did you realize you're on trial? Mr. Nadler's putting you on trial. Everybody's on trial except for them. It's ridiculous. It's ridiculous. They said in their brief, we have overwhelming evidence, and they're afraid to make their case. Think about it. Think about it. It's common sense. Overwhelming evidence to impeach the President of the United States. And then they come here on the first day and they say, you know what? We need some more evidence. Now, let me tell you something. If I showed up in any court in this country and I said, Judge, my case is overwhelming, but I'm not ready to go yet. I need more evidence before I can make my case. I would get thrown out in 2 seconds. And that's exactly what should happen here. That's exactly what should happen here. It's too much to listen to almost. The hypocrisy of the whole thing. And what are the stakes? What are the stakes? There's an election in almost 9 months. Months from now, there's going to be an election. Senators in this body the last time had very wise words. They echoed the words of our founders. A partisan impeachment is like stealing an election. And that's exactly what we have. We have, talk about the framers' worst nightmare. It's a partisan impeachment that they've delivered to your doorstep in an election year. Some of you are upset because you should be in Iowa right now, but instead we're here and they're not ready to go. And it's outrageous. It's outrageous. And the American people won't stand for it, I'll tell you that right now. They're not here to steal one election, they're here to steal 2 elections. It's buried in the small print of their ridiculous articles of impeachment. They want to remove the President Trump from the ballot. They won't tell you that. They don't have the guts to say it directly, but that's exactly what they're here to do. They're asking the Senate to attack one of the most sacred rights we have as Americans, the right to choose our president in an election year. It's never been done before. It shouldn't be done before. Now, the reason it's never been done is because no one ever thought that it would be a good idea for our country, for our children, for our grandchildren, to try to remove a president from a ballot, to deny the American people the right to vote based on a fraudulent investigation conducted in secret with no rights. Well, I could go on, but my point is very simple. It's long past time that we start this so we can end this ridiculous charade and go have an election.
Manager Crow, you should be happy to know that the aid that was provided to Ukraine over the course of the president's administration included lethal weapons. Those were not provided by the previous administration. The suggestion that the Ukraine failed to get any equipment is false. The security assistance was not for funding Ukraine over the summer of 2019. There was no lack of equipment due to the temporary pause. It was future funding. The Ukraine Deputy Minister of Defense, who oversaw U.S. aid shipments, said the hold came and went so quickly, they did not notice any change. Undersecretary of State David Hale explained the paused aid was future assistance, not to keep the Army going now. So the made-up narrative that security assistance was conditioned on Ukraine taking some action on investigations is further disproved by the straightforward fact that the aid was delivered on September 11, 2019, without Ukraine taking any action on any investigation. It's interesting to note that the Obama administration withheld $585 million of promised aid to Egypt in 2013. But the administration's public message was that the money was not officially on hold, as technically it was not due until September 30th, the end of the fiscal year. So they didn't have to disclose the halt to anyone. Sounds like this may be a practice of a number of administrations. In fact, to the president, this president has been concerned about how aid is being put forward. So there have been pauses on foreign aid in a variety of contexts. In September of 2019, the administration announced that it was withholding over $100 million in aid to Afghanistan over concerns about government corruption. In August of 2019, President Trump announced that the administration and Seoul were in talks to substantially increase South Korea's share of the expense of U.S. military support for South Korea. In June, President Trump cut or paused over $550 million in foreign aid to El Salvador, Honduras, and Guatemala because those countries were not fairly sharing the burdens of preventing mass migration to the United States. This is not the only administration. As I said, President Obama withheld hundreds of millions of dollars of aid to Egypt. To be clear, and I want to be clear, Ambassador Yovanovitch herself testified that our policy actually got stronger under President Trump, largely because, unlike the Obama administration, quote, this administration made the decision to provide lethal weapons to Ukraine to help Ukraine fend off Russian aggression. She testified in a deposition before your various committees that, and actually I felt that in the 3 years that I was there, partly because of my efforts, but also the interagency team and President Trump's decision to provide lethal weapons to Ukraine, that our policy actually got stronger. Deputy Assistant Secretary Kent, his name's come up a couple of times, agreed that javelins are incredibly effective weapons at stopping armored advance, and the Russians are scared of them. Ambassador Volker explained that President Trump approved each of the decisions made along the way, and as a result, America's policy towards Ukraine strengthened. So when we want to talk about facts, go to your own discovery and your own witnesses that you called. This all supposedly started because of a whistleblower. Where is that whistleblower?
It is a fair way to proceed with this trial. It is modeled on the Clinton resolution, which had 100 senators supporting it the last time this body considered an impeachment. It requires the House managers to stand up and make their opening statement and make their case. They have delayed bringing this impeachment to this House for 33 days to this body. And it's time to start with this trial. It's a fair process. They will have the opportunity to stand up and make their opening statement. They will get 24 hours to do that. Then the president's attorneys will have a chance to respond. After that, all of you will have 16 hours to ask whatever questions you have of either side. Once that's finished and you have all of that information, we will proceed to the question of witnesses and some of the more difficult questions that will come before this body. We are in favor of this. We believe that once you hear those initial presentations, the only conclusion will be that the president has done absolutely nothing wrong, and that these articles of impeachment do not begin to approach the standard required by the Constitution, and in fact, they themselves will establish nothing beyond those articles. You look at those articles alone and you will determine that there is absolutely no case. So we respectfully ask you to adopt this resolution so that we can begin with this process. It is long past time to start this proceeding, and we are here today to do it. And we hope that the House managers will agree with us and begin this proceeding.
The manager said facts are a stubborn thing. Let me give you some facts. It's from the transcripts. Instead, that he acknowledged any leak he had suggested was based entirely on his own speculation, unconnected to any conversation with the president. Here's the question. What about the aide? Ambassador Volker says that they were tied, that the aide was not tied. Answer. I didn't say that they were conclusively tied either. I said I was presuming it. Question. Okay. And so the president never told you they were tied. Answer. That is correct. Question. So your testimony and Ambassador Volker's testimony is consistent, and the president did not tie investigations, aid to investigations. Answer. That is correct. Ambassador Sondland also testified that he asked President Trump directly about these issues, and the president explicitly told them that he did not want anything from Ukraine. I want nothing. I want nothing. I want no quid pro quo. Tell Zelensky to do the right thing. Similar comments were made to Senator Johnson. Those are the facts. Stubborn, but that's the facts. No one is above the law. Here's the law. As every member of Congress knows, undoubtedly aware, separate from even state secret privileges is the presidential communication executive privilege to communications and performance of a president's responsibilities. The presidential communication privilege has constitutional origins. Courts have recognized a great public interest in preserving the confidentiality of conversations that take place in the president's performance of his official duties because such confidentiality is needed to protect the effectiveness of the executive decision-making process. In Ray Sealed cases, that was decided in the District of Columbia Court of Appeals. The Supreme Court found such a privilege necessary to guarantee the candor of presidential advisors and to provide the president and those who assist him with freedom to explore alternatives in the process of ultimately shaping policies and making decisions, and to do so in a way many would be unwilling to express except in private. For these reasons, presidential conversations are presumptively privileged. There's something else about this privilege. Communications made by presidential advisors, again, quoting courts. And by the way, lawyer lawsuits, we're talking about the impeachment of a president of the United States, duly elected. And the managers are complaining about lawyer lawsuits? The Constitution allows lawyer lawsuits. It's disrespecting the Constitution of the United States to even say that in this chamber. Lawyer lawsuits. Here's the law. Communications made by presidential advisors in the course of preparing advice for the president come under the presidential communications privilege, even when these communications are not made directly to the president. Even when they're not made directly to the president, advisor to advisor. Given the need to provide sufficient elbow room for advisors to obtain information from all knowledgeable sources, the privilege must apply both to communications which These advisors solicit and receive from others as well as those they authorize themselves. The privilege must also extend to communications authored or received in response to solicitations by members of a presidential advisor staff, since in many instances, advisors must rely on their staffs to investigate and issue and formulate advice given to the president. Lawsuits, the Constitution, a dangerous moment for America when an impeachment of a president of the United States is being rushed through because of lawyer lawsuits. The Constitution allows it if necessary. The Constitution demands it if necessary.
Mr. Schiff came here and said he's not asking you to do something he wouldn't do for himself. And the House manager said, we're not asking you to do our jobs for us. And Mr. Schiff came up here and he said, I call Ambassador Bolton. Remember Paul Harvey? It's time for the rest of the story. He didn't call him in the House. He didn't subpoena Ambassador Bolton in the House. I have a letter here from Ambassador Bolton's lawyer. He's the same lawyer that Charlie Kupperman hired. It's dated November 8th. He said, I write as counsel to Dr. Charles Kupperman and to Ambassador John Bolton in response to the letter of November 5th from Chairman Schiff, Chairman Engel, and Acting Chair Maloney, the House chairs, withdrawing the subpoena to Dr. Kupperman. I mentioned that earlier. And to recent published reports announcing that the House chairs do not intend to issue a subpoena to Ambassador Bolton. He goes on and says, we are dismayed that the committees have chosen not to join us in seeking resolution from the judicial branch of this momentous constitutional question. And he ends the letter by saying, if the House chooses not to pursue through subpoena the testimony of Dr. Kupperman and Ambassador Bolton, let the record be clear. That is the House's decision. And they made that decision. They never subpoenaed Ambassador Bolton. They didn't try to call him in the House. And they withdrew the subpoena for Charles Kupperman before the judge could rule, and they asked that the case be mooted. And now they come here and they ask you to issue a subpoena for John Bolton. It's not right.